Great, welcome everybody, bienvenue. As people still slowly join, we'll just start. Welcome to the webinar. You'll hear my dog bark in the background, sorry about that. I just want to acknowledge that Climate Atlantic works throughout Atlantic Canada, all of which is part of the unceded and traditional territories of the Mi'kmaq, Wolastoqiyik, Passamaquoddy, Innu, and Inuit peoples. So again, welcome, bienvenue. You are at the session on municipal liability, climate risk, which focuses on flood risk. There is French interpretation available. If you look at the bottom of the Zoom window, there is a globe that's called interpretation. If you click on that one, you can choose English-French translation. Alors, il y en a l'interprétation de l'anglais en français disponible. En bas,
interpretation is available in French and English. You see at the bottom, there's a globe that says interpretation, where you can choose French and English.
But when we get to the discussion, please feel free to ask your questions in French, in the language of your choice. Une fois qu'on commence les questions et les réponses, vous pouvez
Once you go to Q&A, you can ask questions in French or in English. You have the choice of language to use.
Let's do a little bit of a polling to get to know each other and where you're from. So this is a bit also while we're still waiting. We had a quite high registration for this event. And I forgot to say, I'm Sabina Dietz. I'm the Executive Director of Climate Atlantic. Welcome. And Janelle will take over for the polling. She is also with Climate Atlantic. Janelle, please go ahead.
Thanks, Sabina. Hi, everyone. Good afternoon to maybe most of us. We will see. I am going to start a polling question. So questions, there'll be 3. So I'll read them out loud. There'll be an answer. There'll be an answer you can choose underneath. And then you just keep scrolling down on your screen to answer them all. Let's launch this. So starting at the top, where are you attending from? And do we have different answers? New Brunswick, Newfoundland and Labrador, Nova Scotia, Prince Edward Island, or outside of Atlantic Canada. So go ahead and click on the one that fits you. Next question is, where do you work? And what we mean by that is, do you work with a nonprofit or an NGO, with an Indigenous government, an Indigenous community, within a municipality, provincial government, in the private sector, or other? And then keep scrolling down to fill out the last question there. How familiar are you with climate risk, responsibility, and liability for municipalities? 3 options there: not at all, somewhat, or very familiar. So feel free to fill that out. I'll just get it. People are still clicking on it. Few more seconds here. You want to fill that out. All right. So I'll end poll and I'll share the results so people can see. So as you can see, we have quite a good spread of participants throughout Atlantic Canada, New Brunswick coming in first. And a few of you are outside of Atlantic Canada. Welcome. And where do you work? A lot of you are with municipalities and with NGOs, nonprofits, and a few of you are with provincial government, private sector, and other. And then the last question there, how familiar are you with this topic? 26% said not at all, somewhat, 68%, and very familiar, 6%. So that just gives a little read of each other. Thank you very much for that. And back over to you, Sabina.
Thanks, Janelle. So please feel free to acknowledge also where you're calling in from in the chat. That's always good to know. If in case you didn't know, you've joined a webinar which relates to a report that we released that was developed by East Coast Environmental Law. We released that in late fall. And this report was intended to identify where likely liabilities may occur for municipalities linked to climate change, focusing on flood risk. And the decision to do this was made before Fiona happened, so much more I think pertinent now. And flood risk was chosen in part as well because it touches on so many municipal activities and so many municipal decisions, and it is already felt by many across the entire region. So it's my pleasure now to introduce, before I introduce Tina, I should also say there is quite a lot of time for question and answers after Tina's presentation. So Tina's presentation is only about 20 minutes. A broad overview over the report. So there's plenty of time for questions, and we're not going to cut questions off. Please put them all in the chat, and we are collecting them as Tina presents, and then we will go through them at the end of Tina's presentation. So feel free, any questions relating to the report. So it's my pleasure now to introduce Tina Northrup. She's a staff lawyer at East Coast Environmental Law, which is an environmental law charity that provides public interest environmental law services throughout Atlantic Canada. She's a 2019 graduate of the School of Law at Dalhousie University and was called to the bar in Nova Scotia in 2020. Her practice includes law reform advocacy and public legal education in a number of areas, including biodiversity, species at risk, climate change mitigation and adaptation, energy law, environmental decision-making, and human rights in the environmental context. So Tina, I'm going to hand it over to you, and I think you will be sharing your screen. I'd also ask that everybody stays on mute while she presents. Thank you. Go ahead, Tina.
Great. Thanks, Sabina. And a big thanks to Climate Atlantic for having me and for organizing this. And I will share my screen now just to pull up a PowerPoint presentation and get this up and get us started here. Great. And then, sorry, I just also need to minimize the view grid in my screen. There we go. So as Sabina said, I mean, this presentation today is going to provide an overview of a report that I prepared on behalf of East Coast Environmental Law for Climate Atlantic in the autumn. The report is current up to the end of October, and it was released in late autumn. So new developments since then won't necessarily be taken into account in the information, but certainly, as Sabina mentioned, a lot of timely issues discussed throughout. So the shape of the presentation today, and I just need to figure out, there we go, will look basically like this, kind of introduction to the report and some key terms and concepts used within it, just so you have a sense of the way that we approached the research question, and of course what our key research questions were. Then an overview of the key findings, which are also presented at the beginning of the report in a separate summary document that Climate Atlantic released along with the full report. And then just a few spotlights on some topics that might be particularly noteworthy or of interest, including some intersections between some of the different topics involved. So really a high level approach, as Sabina said, about 20 minutes, and then quite a lot of time for questions and answers afterwards. And this is just a short blurb also about East Coast Environmental Law, which Sabina said a little bit about already, but just maybe to clarify and to provide some context for the nature of this report and the discussions that led to it. My organization is one that engages in quite a lot of public legal education and development of legal research and reporting that is intended to help members of the public, but also environmental organizations or organizations working in the environmental law sphere to some extent, understand the law better so that we can collectively work towards the ends that we share as common goals. And so this report came out of what I think was a really productive collaboration between Climate Atlantic and East Coast Environmental Law, and it was really a pleasure to work on it and to work with the Climate Atlantic team. So the key questions addressed in the report are these. What are municipalities' legal responsibilities to consider, manage, and disclose climate change flood risks? And what liabilities could municipalities face if they fail to meet those responsibilities? So just a few key terms and concepts that are kind of necessary to understand the way that we approached these questions. By climate change flood risks, we mean risk created by the combination of flood hazards, and specifically climate change flood hazards, and then vulnerability to harm as a result of those hazards. So when we speak of climate change flood hazards, we're talking about the kind of hazards that have become more and more common and noticeable in recent years, and that are projected to continue out in the years to come. Hazards created by sea level rise, coastal storm surges, increased precipitation, storm frequency, storm intensity, those kinds of things. And then risks, of course, when we think about our vulnerability to those hazards, risks can include all kinds of loss and damage that come as a result of those hazards impacting us in destructive ways. When we talk about municipalities considering, managing, and disclosing flood risks, these are the general ways that we approached those terms. So considering, taking into account in municipal decision-making, deciding whether or not and how climate change flood risks need to inform things like infrastructure investments, land use planning, development permitting, those kinds of municipal activities. Managing climate change flood risks, similarly taking actions to avoid, mitigate, or even potentially accept risks. I mean, there may be risks that we simply have to accept because we don't necessarily have the resources or capacity to mitigate them. And then disclosing, this is sharing information or providing access to information about the future climate change flood risks that are projected or anticipated, and whether that's sharing with the public at large or with specific individuals who might be particularly vulnerable. And just a little point worth noting at the outset, and something that we were careful to note in the report as well. I mean, the information and analysis presented in the report are really not intended to frighten or badger municipalities, or say, you are going to be sued if you're not paying attention to these kinds of things, or you're going to be held liable. Really, this was intended to spark conversations, to get everybody thinking about what's on the horizon and what might be necessary to deal with what's on the horizon. And so certainly we hope that the report does inspire those conversations and further thought and deliberation as to what is necessary and what is possible in the years to come. So getting now into an overview of the report as a whole, it identifies 5 primary categories of potential sources of municipal responsibility to consider, manage, and disclose climate change flood risks. And we looked at municipalities throughout all of Atlantic Canada. So those 5 categories are the enabling legislation of municipalities in the region, external legislation that imposes liability for environmental harms and potentially related personal injuries, the common law, which is law that emerges through decision-making by courts rather than law that is written by governments, the Constitution, and also funding agreements and other contractual relationships where certain requirements may be imposed by the nature of the agreement. And then we look at those potential sources of responsibility with an eye to 3 primary spheres of municipal activity. So management of municipal infrastructure, land use planning, and development permitting. So then, in terms of key findings of the report with respect to those 5 categories, what we found when we looked at municipalities enabling legislation throughout Atlantic Canada is that in the enabling statutes primarily, so thinking about the statutes that formally constitute and empower municipalities throughout Atlantic Canada, we don't yet see at this point clearly legislated responsibilities to consider, manage, and disclose climate change flood risks. Often the terms climate change or flooding aren't really appearing at all in those statutes. So we're looking here, when I say clearly legislated responsibilities, looking really at mandatory requirements that are imposed explicitly in statutes and regulations. Newfoundland and Labrador is an interesting kind of outlier in one sense, or maybe rather than saying outlier, it's right now the sole Atlantic Canadian province that has incorporated explicitly some climate change flood risks into its provincial flood management regime, but they are set out right now in policy that is then structured to be intersecting with and working in tandem with legislation. And I'll come back to that after going through this overview of the key findings for the categories. We'll take a closer look at exactly what Newfoundland and Labrador has done in that respect. With the external legislation category, the report doesn't attempt to provide a comprehensive survey of what is out there. Essentially, it chose a couple of illustrative examples and provided some high-level information, just addressing the fact that when it comes to considering and taking into account climate change, flood hazards, and risks that are attendant upon those hazards, this impacts the way in which municipalities may need to think about their potential liability under statutes and regulations that deal with environmental harms in whatever respect. So, if we're thinking about environment acts at the provincial level or the federal level, sort of statutes that, for example, say, unlawful release of certain contaminants into the environment or into water bodies or into fish-bearing waters, can create liability. Municipalities need to be aware of that in the context of climate change flood risk, because of course there are certain flood risks that can intersect with breakdowns of municipal infrastructure or incapacity to handle storm surges or flooding that may then result in environmental harms happening that are then going to be potentially constituting offenses under external legislation. Category 3, the common law. One of the key findings of the report is that we have not yet seen Canadian court decisions that are explicitly addressing municipal responsibilities to consider, manage, or disclose climate change flood risks. And what I was looking for here in looking for those cases were decisions in which courts were asked specifically to consider liability for flood loss and damage in the context of climate change. So looking for that terminology in particular, and not seeing that yet. We've got quite a lot of case law in Canada that deals with municipal responsibility for flood loss and damage more generally, but not yet case law that's addressing that in the context of climate change flooding. So with that in mind, then, the report in identifying common law sources of liability for climate change, flood loss and damage, it has to infer or, to some extent kind of speculate outwards based on the areas of the common law that have historically been the areas where municipal liability tends to accrue. We're talking about flood loss and damage. So it identifies those sources and talks a bit about all of them, but it then focuses primarily on negligence because my research indicates that negligence is the area of the common law where municipal liability is most likely to accrue when we're talking about common law liability for failure to prepare. The report also discusses the common law of failure to warn, because of course, one of the key questions has to do with disclosure of climate change flood risk. Failure to warn is treated in the report as a category of negligence. And this is one of the things that we will come back to in this presentation as an area to spotlight. So I won't say too much more about it for now. We'll return to it in just a couple of minutes. With respect to the Constitution, this discussion in the report emerged from questions having to do with the potential impacts of the kinds of big climate change litigation cases that we're seeing across Canada and elsewhere in the world. So a broader question about the extent to which municipalities maybe need to be thinking about that kind of sort of large scale climate change litigation and how it might affect them in the context of the topic at issue here. So really this section of the report provides a high level overview of the four major climate change litigation cases we've seen in Canada so far. And up to this point, we haven't seen cases where municipalities have been the defendants. The cases that we've seen so far have been taken against the federal government and or provincial governments. And so that's not to suggest that we might never see cases where municipalities are the defendants. it's an evolving area of the law, and there's a lot in play in terms of the complexity of this area of the law. So one of the findings of the report is that even though we haven't yet seen a lot of success in terms of success of climate change litigation, and we haven't seen governments being held liable for failing to take adequate action to mitigate or adapt to climate change, because it's an evolving area, and because the common law and because court interpretations of the Canadian Charter of Rights and Freedoms evolve over time and are evolving right now to confront the climate crisis, it's difficult to know exactly what this area of the law might look like in future. So certainly something to be aware of and to keep an eye on. And then finally, with category 5, the funding agreements and other contractual relationships. Again, this is an area of the report that doesn't attempt to provide a comprehensive survey, but instead just offers some high-level kind of introductory thoughts about this, really just flagging the reality that when we're thinking about legal obligations, we don't just have obligations that come to us through written laws enacted by governments or through the common law as it's developed by courts. We can also enter willingly into relationships in which we willingly assume legal obligations, and contractual relationships, whether or not associated with funding agreements, are relationships where we can assume certain responsibilities. So it's always important to keep in mind that as municipalities are seeking funding for infrastructure management,
Financement pour la gestion des infrastructures, et on veut également d'autres soutiens financiers qui permettent d'aller l'avant pour réaliser nos buts et objectifs. Les ententes sous-jacentes peuvent établir des exigences juridiques de considérer ou de gérer les risques de changement climatique. Et c'est important d'être attention à ces détails.
So with that kind of very high level overview of the key findings for the 5 categories addressed in the report, I'll circle back now to the comments I was mentioning about Newfoundland and Labrador being a bit of an outlier, or having taken some steps that we haven't yet seen taken in the other provinces. So right now, the statutes in Newfoundland and Labrador that empower municipalities in the province, so the Municipalities Act and then the respective statutes empowering the 3 cities listed here on this slide, they don't impose explicit requirements upon municipalities to consider, manage, or disclose climate change flood risks, and neither does the Urban and Rural Planning Act, which grants land use planning powers to municipalities in the province. But what we see in the province is an interesting intersection between the land use and development powers set out in the enabling statutes listed here, and then a provincial policy for floodplain management. And that policy has been created in such a way that it does then inform land use planning and development in the province. So what we see is that the Urban and Rural Planning Act in Newfoundland and Labrador requires that municipalities, when they're adopting land use plans and associated development regulations, submit them to the Department of Municipal and Provincial Affairs for review before they're adopted. And then the Minister of Municipal and Provincial Affairs also has to review land use plans and development regulations after adoption to determine if they're contrary to law or contrary to a policy of the government. And because we have this review happening where the minister is meant to be looking at land use plans and development regulations and assessing, do these accord with or are they contrary to law or policy, that opens the door to bringing in this policy for floodplain management, and indicates that at the ministerial level, at the very least, that policy for floodplain management ought to be taken into account as land use plans and development regulations are being reviewed, which then suggests that there in practice should be a kind of trickle down effect in which you would assume that there's an expectation being set that when municipalities are engaging in the work of proposing land use plans and development regulations, that they're also going to be taking that floodplain management policy into account. And the policy also, interestingly sets up a framework whereby if the province identifies climate change flood zones, that developments in such zones would ultimately need to be approved by the minister before they can proceed. So some interesting things happening in Newfoundland and Labrador in the sense that there's movement to create policy that then through kind of incorporation into the legal land use planning and development regime takes on a significance in terms of land use planning and development. Now, moving on to take a look, a bit of a closer look at negligence and failure to warn. These are areas of the law where we could spend a lot of time probably talking about both of these, and I'm happy to spend a lot of time talking about them if that's going to be a focus of the Q&A after the presentation. I'll try to keep things relatively simple for now, but I think providing just a few foundational points will maybe help to shape the conversation going forward. So just so we're on the same page, I think negligence is likely, a legal wrongdoing that most on the line have heard of or potentially even had some familiarity with. At heart, to put it in its most distilled and essential terms, negligence is a legal wrongdoing that has to do with the failure to take reasonable care to avoid causing harm to those that we know or that we ought to know could be hurt by our actions. Now, in litigation, and in civil litigation in particular, this is what we're discussing here. If a plaintiff, so a person who has been harmed and who commences litigation, alleges that they've been harmed by negligence, they're going to have three things that they need to prove to the court in order to hold a defendant liable for negligence. They're going to need to prove that the defendant owed them a duty of care. They're going to need to prove that the defendant failed to meet the applicable standard of care. And they're going to need to prove that the defendant, in failing to meet that standard of care, caused them harm and particularly caused them foreseeable harm. Those are the basic elements of the common law of negligence. And just elaborating a little bit on those three elements. The duty of care is an interesting one when we think about governmental responsibility and governmental liability for negligence, including liability that might potentially be accrued by municipal governments. So often it's the case that the law will really hesitate, or courts will hesitate, to find that public authorities carrying out sort of public duties owe private duties of care to private individuals. And this is because many public duties that are owed by governments or governmental representatives are understood by the courts as being owed more broadly to the public at large, rather than being owed to specific persons. So it is not necessarily the case that a private individual alleging negligence against a government is always going to be able to establish that the government owed them a duty of care. And there have been many cases in which the courts have, in fact, declined to find a duty of care, just as a starting point. But there are also a number of well-established situations in which the law will recognize that a duty of care is owed by government. And in the municipal law context, one of the places we see that is with respect to building inspection and permitting. So if we're thinking about the work that municipal building inspectors and municipal staff delivering occupancy permits and the like, the spheres in which that work happens, that is a sphere in which the governments have accepted that a duty of care is owed to the persons who are going to inhabit and use buildings that have been approved by municipalities. The standard of care is a standard that courts will attempt to determine as objectively as possible, typically by looking at relevant kind of industrial or professional standards, best practices set essentially by the field as a whole. Sometimes requirements that have been adopted by standard setting bodies will be helpful in establishing it. Essentially, it's an exercise where you're looking to see, well, what would kind of the average reasonable person in the same circumstances kind of have done? What would be the professional expectation or the industrial expectation on this person? And then finally, with respect to causation, what we're looking at here is for both causation in fact. So the action or failure to act actually to cause the harm, and causation in law, which has to do really with a concept of remoteness. Is the harm something that could have been reasonably conceived of or understood as a harm that would likely or potentially follow from the activity in question? And recognizing that that I'm already coming up on the 20-minute mark and don't want to take too much time, I'll just take another couple of minutes on negligence and failure to warn, and then we can move into questions. So I think the important thing, and probably the thing that we're maybe going to really want to get at in our discussion today, has to do with this core policy and operational distinction that the common law of negligence has set out with respect to government action in particular. So assuming that a duty of care does exist, putting aside for the moment questions about the relevant standard of care, Canada's courts have recognized that there are certain governmental decisions that should not be held liable in negligence. And this recognition stems in large part, and I would say primarily, from the court's interest in preserving the constitutional separation of powers between the three branches of Canadian government as those branches are conceived of in our Constitution. So the executive branch, where we have government executives like the Prime Minister and federal ministers at the federal level, the Premier and their ministers at the provincial level. That's the executive, legislative, obviously the whole government body in terms of the body that comes together to legislate, to debate and pass laws. And judicial, the branch that is comprised of the courts in Canada. The courts are very aware that there are certain roles assigned to the executive and legislative branches under the Constitution that are simply not the roles of the courts, and are roles with which the court should not interfere. Courts do not want to interfere in what they describe as the kind of very deliberative, polycentric decision-making that democratically elected representatives are meant to be doing under our constitutional structure. So to protect that separation of powers and to draw a line whereby courts will avoid crossing into those protected spheres of government decision-making and activity, the courts have said, well, we're going to then recognize this protected sphere where we won't even intrude upon it. We won't be looking for government negligence in that sphere. It's a protected sphere, and that's the core policy sphere. So core policy decision, when it's recognized by the courts, isn't going to be liable in negligence. These are decisions that in the court's view really reflect the core roles and competencies of the executive and legislative branches of government. So we're looking for decisions based on public policy considerations, polycentric analysis, deliberation, value judgments, often value judgments where there are sort of many kind of competing interests at stake. Sometimes, some might not necessarily be clearly better or stronger, more prudent than others. Often this is a sphere in which governments have to make really hard decisions, knowing that ultimately some are going to be left unhappily, and that's just the nature of government decision-making. The courts recognize that. And so that is the sphere that we're talking about when we think about the sphere that's protected from negligence liability. Of course, in practice, then, what often happens is that it can be difficult to understand, well, what is going to be a protected policy decision versus an operational decision that is not going to be protected and that could, in fact, be subject to liability in negligence. And so in the Supreme Court of Canada's most recent decision providing guidance on this, the court sets out a number of factors and goes into some length to discuss those factors that ought to help provide guidance when trying to determine the difference between core policy and operational decisions. So these factors are the level and responsibilities of the decision maker. The higher the level, the more likely it's going to be a core policy decision. But again, none of these factors are determinative. They're just factors that need to be considered and weighed. The process by which the decision was made, deliberative processes involving debate, consultations, attempts to create sort of broad-based policy directions forward, those are the kinds of processes that are more likely to lean towards a core policy identification. Nature and extent of budgetary considerations, and then also extent to which the decision was based on objective criteria. This is an interesting one because the courts are saying essentially, it is often the role of government to engage in subjective value-based decision-making where many competing considerations are being made. So that is sort of in the realm of core policy. But if you're looking at decisions based on objective criteria, such as, for example, is one engineering design objectively better than the other based on its ability to meet our needs, that is the kind of thing that's going to start to look more like an operational decision. So something that we can come back to in the discussion, I think ultimately kind of summarizing this, what the courts are looking for in core policy decision making, in addition to it truly being a core policy decision, also they're looking for it to be a decision made rationally and in good faith. So rationally on the basis of information, we're looking for decisions that are informed and in good faith, meaning essentially in the absence of bad faith. So, a decision that is clearly not made for ulterior purposes, out of bias, out of, any of the things that tend to run governments into trouble when trying to think about good government decision-making and unlawful or improper government decision-making. And then finally, failure to warn. Failure to warn is an area of the law where we actually have some inconsistency in the case law. And so bearing in mind that inconsistency, the report treats failure to warn as a category of negligence that shares basically the same analytical framework as the common law of negligence, but also requires an additional element, which is proof of a positive duty to act. So actually having a positive duty to warn someone of danger, even if you yourself are not the cause of the danger. And that positive duty is characterized in the law as being based on a relationship of special proximity. So the reason that the report talks about failure to warn is, again, because there's this, one of the key questions in the report has to do with municipal responsibilities to disclose climate change flood risks and potential liabilities that might follow from failing to disclose flood risks. So one of the ways of getting at that question is, well, how does the law create potential liability for failure to disclose information or warn of risk or danger if there isn't a clear duty set out in legislation, which for the most part we don't see in Atlantic Canada as things stand now. So we looked at failure to warn for that reason. And we do see in the case law a number of decisions where municipalities or municipal representatives or staff of some kind or another have been held liable for failure to warn. These cases arise in a number of different situations, but the main ones are negligent building inspection and permitting, failure to warn of hazardous or faulty municipal infrastructure, and failure to warn of hazards that are specially known to municipalities. Again, maybe having to do with municipal works and services or areas maintained such as campgrounds or parks or roads. And in my research, really the area where we saw most liability accruing was with negligent building inspection and permitting. And so what the report indicates is that if and when the law develops in this area and begins to account potentially for allegations of liability for failure to warn of climate change flood hazards, a place that we can imagine as being a place where liability might very well accrue would be, say, failure to warn of relevant risks when allowing developments to be built in certain areas, or when allowing renovations of houses or occupation of buildings, when municipalities know very well on the basis of information that they hold that that there's a risk there, and when they don't disclose that risk when engaging in permitting. So we don't yet see case law spelling that out exactly, not using the explicit terms that we're using today, but certainly an area where I could imagine the law moving in the future. So I think we'll stop it there for now, recognizing that I've gone over 20 minutes, and but then in conversation, happy to return to any of this.
Great, thank you very much, Tina. Also, just to remind everybody that the English and the French reports are available on our website, and Cassandra or Janelle, if you could just put the links there of both the English and the French. So it's quite a lengthy report that you've provided for us. So I want to go a bit back. We've got a couple of questions, but I want to just add a couple things or a couple of questions that I want to go back to. One is, in your report at the beginning, you mentioned that that the report didn't assess the frequency of lawsuits. And I remember from even 10 years ago, hearing about cases across the country about, liability in terms of flood risk. One of them was in, I think, Mississauga, Ontario. And they never seemed to make it to court, or they're not mentioned. They didn't end up with anything. So why is this so important to state that you did not assess that? Is that related to, things get resolved before they ever make it to the court?
Mm-hmm. Yeah, and thanks for that question, Sabina. Yeah, so two things. I mean, certainly one of the reasons the report states it is to acknowledge that there might be cases that municipalities have anecdotal knowledge of, because they hear of them being initiated, or maybe sort of following them, but then ultimately they settle or they are discontinued for other reasons. And so there might be cases that are known about but aren't addressed in the report. And I wanted to acknowledge that, because certainly in terms of my research and the information and analysis presented, when cases settle out of the court, you don't get the benefit of court analysis in terms of being able to then provide commentary on the shape of the law as it currently stands, because cases can be settled, just for the simple reason that parties don't want to take the risk of going to court and potentially losing. So they're not necessarily deciding amongst themselves what the law is. They're just deciding not to take the risk. But then certainly it is the case that when cases are initiated and ultimately don't proceed, often it is because parties are settling. And so, municipalities could very well be exposed to liability, and could be, finding themselves in situations where they're deeming it more appropriate just to settle quietly rather than going to court. And so you don't necessarily then have the all of the costs and expenses of going through the whole court process, but there might be then whatever expense is associated with needing to reach a settlement.
Mm-hmm. Thanks. A second question, I should disclose to the attendees that I was town councillor for a year and a half. So, negligence and municipal liability is, of course, for any councillor, municipal staff, it is always there. But the piece that I also thought of just making sure that this is clear is that in general, we know municipalities are creatures of the provincial government. That's when you presented the Newfoundland case, but also you presented all in the report, all the provincial legislation that governs municipalities. So what's sort of curious, you highlighted Newfoundland, where there's sort of an intersection between what the municipalities, the enabling legislation for the municipality and the policy. And yet my understanding is, because all provinces have policies, that unless there's a legislation, the policies are guidance documents. So, and sort of then going back to that, putting Newfoundland aside, in general, considering or disclosing climate change considerations, unless it is in the legislation somewhere, there's a limbo for municipalities. With the caveat of all the other things you said, of course.
Yeah. I think certainly I think a limbo is probably a good way of describing it. I mean, certainly I think one of the takeaways of the report, or maybe something that anybody would walk away from in reading the report, is that there aren't necessarily clear and explicit answers to any of these questions. So many of the answers given in the report are, well, if you take this into account and then maybe this, and they'll think about the way it intersects with this, then maybe you find yourself here. But even then it's hard to say for sure. So yes, but it is the case that, we often see provincial policies or even provincial responsibilities, so responsibilities held by the provincial government, then being structured in ways that intersect with municipal responsibilities. So we always have to be really attentive to those intersections and be thinking about the ways that they impact.
I think that's a really good point. We have one question from Triffy Parsons who asked, should municipalities have a policy for climate change? What do you think?
I mean, in general, I would say yes. I mean, one of the things the report discusses is that, I mean, certainly with respect to the law of negligence in particular, it is in municipalities' best interest, just as a general rule. And you know, I think we probably should have said this at the outset. I think the report makes it very clear is that the report is trying to provide high-level information and analysis, but can't constitute legal advice. And so similarly, you know, anything that I say today has to remain at a high level and can't constitute like tailored legal opinion or advice that's specific to any one circumstance. But that being said, as a general rule, given the shape of the common law of negligence in Canada, it is in a government's best interest to craft policy in areas where you know, where it thinks that as a result of its governing decisions, it could potentially, you know, attract liability for negligence. And that just applies in, you know, in general, not just in the context of climate change, but that, you know, you want to be thinking about then the kinds of things that the courts have said about, you know, what is good policy or what is sort of true policy or core policy, and what do we really mean by that kind of like rational, good faith decision making. And so, but certainly I think having policies in place that clearly articulate where a municipality is with respect to these issues is helpful from that perspective.
Thank you. Stephanie Arnold's question is the following. Might the court take into consideration the capacity of a municipality, for example, small rural town versus a large urban city, in determining standard of care? Might this consideration apply in duty of care?
So that's a difficult question. I mean, standard of care is one where I think, you know, that's a difficult question to answer with a straight yes or no question, is I think probably the best I can say about that. I think that a court would take it into consideration, but it wouldn't necessarily be determinative. It can sometimes, or to put that another way, it wouldn't necessarily be the case that a court would accept that, you know, a smaller or, you know, a less wealthy municipality, a municipality with less resources at its fingertips, wouldn't necessarily be held to a lower standard, depending on the issue. There are going to be some issues where a court is going to say, well, if you undertake a certain kind of activity, you need to be held to the same standard of, you know, basic public safety as everyone else, because that's just how, you know, we protect the public. So it really depends on the factors. But when it comes to the policy context, certainly that is a consideration in terms of thinking about the core policy and operational decision distinction. So stepping back from the standard of care question and thinking about, you know, if you're a rural municipality with limited resources at your fingertips and you're just trying to figure out exactly what you can do with respect to climate change mitigation or adaptation in this context, you know, certainly it's within a municipality's power and interest to look carefully at its resources and be making policy decisions and articulating policy decisions that that are essentially saying, you know, this is what we know we can do and this is what we know we can't do based on our current resources, and then using those policy decisions and determinations to then kind of figure out what kinds of operational steps might be possible or might just be, you know, imprudent or unwise under the circumstances.
Thanks. I think that sort of leads into the whole core policy, which was a really interesting field for me as a counselor, because that's where counselors, provincial governments, etc., the lawmakers essentially sit in the core policy area, right? And often I think what I've seen in smaller communities, that is often, well, that can be partially uninformed decision making. And so I want to slip over into a bit on based on decisions being based on rational and good faith, because those decisions on policy direction for municipality are based on the information that they can get. And so I see so much potential for things going wrong. Like even if you present, let's say, a flood risk map to a municipal council and say, these are, and you have, you know, credible people that do these presentations, a municipal council can still make different decisions. And I do understand that depends on priorities. But if these decisions are can be proven to be wrong in terms of best information, so not the best information is used, there seems to be, to me, a lot of sort of gray area where things can go wrong, judging, you know, what is rational, what is good faith, in even that core policy area, which is, I understand why it is protected, why there is, you know, you have to be able to make priorities when you govern. And that's clear, you know, whether it's housing or flood risk management, where do you put your money? Where is your where are your strategic priorities as a community? Can you comment on that a bit?
Sure. And I think, I think you're pointing to realities that I can only agree with to some, you know, like I think you're right. Decision making is difficult. There's so much, you know, depending on the situation, often, you know, a lot of information can be provided, or potentially you only have access to a limited amount of information, and potentially, you know, that information could be challenged by other information or other sources. And so you can, you know, quickly go down into a rabbit hole with some things like that. I think that, you know, when thinking about the way that courts have approached the core policy kind of, the core policy sphere and conceptualized it, I think it likely that you know, a court is not, and courts generally do not want to the phrase that is often used is that, you know, they are not academies of science, right? Like if a government has made a decision on the basis of information that was before it, a court is typically going to be quite reluctant to engage in some kind of, you know, scientific exercise whereby the parties to litigation are allowed to come in and bring in bunches of conflicting reports and then ask the court to sort of weigh out and come to some new kind of factual determination as to what is the best possible scientific information that should have then informed the government's decision. Courts are typically quite reluctant to engage in that. And so it is more often the case, and this, you know, this goes beyond negligence and goes into government policy setting of various different kinds when courts are asked to look at it. I mean, if it's clear enough that the information, you know, was like reliable enough, and a government could, you know, a government was, you know, unless there's anything clearly like egregiously suspect about the information, then usually I think a court is going to accept that a government had evidence before it that would allow it to reach the conclusion it reached, whether or not there was also conflicting evidence or information suggesting they could have gone a different way. So a court is typically not going to really dig its hands too deeply into that, again, unless there's something really clearly wrong on the face of the information used, you know. So I think, you know, hopefully that answers your question about that. And I'm just trying to think now. I feel that there was a second part to your question. I feel I might have lost it in the information piece. Maybe it had to do with the good faith piece more so than the rational decision making. I mean, the good faith issue, this is a phrase that is often just not defined very clearly in the law, and is typically defined more by contrasting it with bad faith, right? So with good faith, bad faith, really, as I said earlier, good faith tends to be the absence of bad faith. And when we think about bad faith, we think about biased decision-making, or decision-making that is clearly improper for other reasons. So in this context, if we're looking at a policy decision that is effectively a kind of, I mean, not to be glib, but effectively, a kind of, well, we're going to set a policy of not doing anything about this because we just don't want to, it's a hassle. Like, that's not a good faith decision, but so it's things like that. I mean, usually courts are typically extraordinarily reluctant to find bad faith in government decision making. There's a presumption that governments operate in good faith.
Thanks. So there is a question that relates to something that you said earlier from Tiffy, and that I can just expand that. So if there is a municipal campsite or a park, and that's the case across a lot of the coastal areas and inland flood risk areas. So if it's in a flood risk area, in an area that's known for flooding, should we have a policy to notify, like the should?
Yeah, that's that's an interesting question. I think going back to the comments I made earlier, just sort of a need to be cautious about providing comments in this session that are going to sound like legal advice. I could say that, at a high level, certainly when we've seen cases in the existing case law where there are, campgrounds or parks owned by municipalities, and there are hazards such as diving hazards, objects in the lake, shallow waters, etc., municipalities have been found liable for failing to warn residents of those hazards. So speaking generally, I would say that I think there's a pretty clear analogy to be made between, knowing of a diving hazard and needing to put up some kind of sign, for example, or alerting users in other ways, and knowing of a flood hazard and it being prudent to notify users and as well. So I think there's a clear line there, and whatever I think the important thing to keep in mind is always that when it comes to liability, when somebody's been harmed, if they're able to access legal representation, if they can afford to commence litigation, then the likelihood is that their lawyer is going to try whatever they think might stick. Lawyers tend to take a kind of throw everything at the wall and see what sticks kind of approach. So certainly I would anticipate that you would see somebody at least making that argument in litigation if somebody were using a campground and it flooded suddenly or terribly and they were harmed in some way. I would expect them to come looking for municipal liability. So I think that's the thing to keep in mind too. If you can anticipate or imagine somebody trying that, then it's likely a good idea to prepare yourself for it as best you can.
And I think in most cases, in any case, municipalities have quite a bit of experience with these claims of liability. I'm just thinking it's winter, snow removal is happening, and there are all sorts of cases where you can imagine, claims of negligence because the sidewalk wasn't plowed in time, or somebody tripped over a step in the sidewalk or slipped. So all of these things, I think they can probably be laid over into the climate change and flood risk area. It's the same kind of principles. I mean, we don't hear that many cases going to court. And I suspect that goes again back to your core policy decision and then operational and budget decisions. And there's only so much that municipalities can do. And that goes back maybe to what was mentioned earlier about, is there any consideration for the capacity of municipalities? But then smaller communities have smaller budgets with different priorities and cannot spend that much money. So I think that sort of links it back up into policy decision. There's a direct question around which I know has happened across Atlantic Canada, from Daniel Bryce. If flood risk areas have been mapped, but the municipality has not yet developed policy to deal with these areas, such as zoning and development restrictions, would there likely still be a requirement to disclose this information that touches on your disclosure requirements? Or is there an opportunity to place the knowledge in the sphere of core activities while this type of deliberation is occurring?
So I'm going to assume, I think for the purposes of the answer, that that the last part of that question about placing the knowledge in the sphere of core activities, that the questioner maybe meant core policy there.
Yeah, I think so. So. Yeah. So protected from liability. Yeah.
Yeah. So that's an interesting question, and in the report, I go so far as to say that I go so far as to acknowledge that municipalities might find themselves asking that question, if we're wondering about whether or not to disclose information, could we maybe protect ourselves from liability for failing to disclose or failing to warn by making a policy that we're not going to warn? And I was unable to find any case law that would answer this question. And so my comments along these lines are, I wouldn't say speculative, but certainly based on a kind of more holistic, just kind of impression of the law and the reasoning that the courts have offered to date on this field, and both on the core policy front and in failure to warn. I think it very unlikely that a court would find a kind of blanket policy of choosing not to disclose as a good faith, rational decision, particularly in situations where public safety is clearly a key factor in risk. Because I think governance are understood to have responsibilities to protect public safety to varying degrees, obviously, but certainly I think that is something that generally is understood and shared and as an understanding of requirements of governments. And so I think that probably an attempt to protect oneself from liability by creating a policy like that would certainly be vulnerable to dismissal by the courts. Although, I can't say that for sure because we simply haven't seen case law, but I would be very cautious about trying to protect oneself in that way. I think, it's an interesting issue. And one of the things that the report kind of hints at a little bit, and I had an additional slide on this in the PowerPoint, but I figured I would just kind of end and we could come back to this in conversation if it came up. But the discussions about what might be necessary to disclose, it doesn't turn entirely on the failure to warn piece in terms of thinking about potential liabilities under the common law. One of the things the report talks a little bit about is that municipalities throughout Atlantic Canada do have various access to information requirements that they need to follow under their enabling statutes. So most of the enabling statutes throughout Atlantic Canada have some kind of access to information requirement included within it, and they vary province by province, and also even within provinces, some of the acts say slightly different things with respect to different kinds of municipalities. But generally, as a very high level statement, a common trend is that when municipalities are when they're engaging with information or documents that have been put before them that are the kinds of documents that they're using as the bases for their decision making, those kinds of documents typically are the kinds of documents that are going to be subject to access to information requirements. So you end up finding yourselves potentially in a bit of a circle here, right? Where it's in your best interest to be coming to policy decisions to determine how you're going to deal with issues. And in the disclosure context, if you're trying to decide, well, what do we need to do about climate change, flooding? What do we need to disclose? If you're looking at information that's in front of you, that's the basis for that decision, it might well be the reality that under the very basic access to information requirements in your enabling statute, all that information needs to be made public upon request anyway. And so, the ways that this can play out in practice, I think, can vary case by case and situation by situation, depending on what the requirements actually say in the various statutes. But just important to keep in mind that there tends to be this presumption that unless information needs to be kept confidential for all various reasons why some information is not subject to access to information requirements, then maybe the information that you have in front of you needs to be publicly released anyway if somebody were to apply for it.
Yeah, thanks, Tina. I think that sort of speaks to the whole idea of transparency and accountability in local governments, right? And I mean, in New Brunswick, the only two things you can keep secret, I'm putting that in quotation marks, are HR issues and financial issues that touch on potential land transactions, etc. So, and sort of from a public policy perspective, you know, for councillors, I think it's more logical to disclose what actually has been received as information or what they're going to decide on in terms of bylaws and zoning. If they disclose that right away, have their deliberations in the open, they still need to make those decisions, you know, based on the best information available on whether to go this way or that. But at least then it's all in the open anyway. And the way I understand New Brunswick's Act anyway, it's pretty specific on being very transparent on these things. So I appreciate that very much. I'm going to go back to the negligence, because I think negligence is still really, you know, it is in municipal work. I think it's always there. Liability and negligence. It's always there for various reasons. Probably also depends on the size of the community. I think your comment, and you put that in color, or we have that in a box in the report. And I just want to ask again, I want to hammer that a bit home a bit. Your comment about burying one's head in the sand, not being rational nor good faith. Elaborate a bit on that, because I've worked in the climate space for the last almost 13 years now in the adaptation space, and the most frustrating piece is municipal governments, in fact, burying their head in the sand, partially because of capacity issues. You can't deal with anything more, partially for HR issues, partially for just not understanding climate risk. But I think we've passed that time where we can simply step aside and say, well, nobody's telling us what to do, so we just don't have to do anything. So this burying one's head in the sand, I think maybe you can. And throughout your report, you have sort of, you touch on these, what would be better practice now, and what you feel, your judgment, what you feel is evolving, right? The whole sphere of liability and of the court decisions, you know, cases that currently are not there, but we know they're sitting somewhere on the sides, just waiting to be brought forward. And so what do you recommend best practices for municipalities when they're thinking about that, sort of just as the counter to burying your head in the sand for whatever? And this is meant both negative on my end, but both also very realistic, because sometimes there's nothing else you can do but bury your head in the sand as a municipal government. So just throwing this out at you.
Sure. And I guess, so the starting point for that is to say that, that comment about burying one's head in the sand, not being kind of rational or good faith response, that does emerge from case law. The courts haven't used that exact language. I used kind of colloquial language that I thought would have an impact to readers. But we have seen the courts say in the past, when weighing this protective sphere and describing the rationale for this protective sphere that protects policy decisions, true policy or core policy decisions, depending on the phrase that's been used historically. Certainly, there's been, the courts have made it clear that simply ignoring a problem isn't good enough. So I would say that statement has come through clearly from the case law. You can't just ignore a problem. And you can't call ignoring a problem your policy response either. So with that as the kind of context for that comment, and just making it clear that is tied to commentary that we've seen from the courts over the past number of decades, in the context of climate change and the kind of evolution you're describing, I would agree that we're no longer at a point where we're simply ignoring the problem is going to be recognized as an appropriate thing to do. And, maybe I think, even a decade ago, there might've been questions about that. If I look at decisions from courts from a decade ago that sort of comment on climate change and, even recognize it was a problem, they don't necessarily recognize it in the same language that we're seeing today, right now. Right now we're seeing language where the courts are using terms like, existential crisis, or, this is they're using that kind of language. We're seeing increasingly provincial governments and the federal governments using language of emergency. Nova Scotia, in the climate change plan for clean growth that came out with in December, provincial government said, we're facing a climate emergency. It's the first time I've seen them use, well, actually not the first time, but it's the past couple of years have been the first time I've seen the government of Nova Scotia begin to use that language of emergency. So discourse is changing, and I think, public understandings of the reality of the climate emergency really have changed a lot in the past number of years. So I think municipalities need to, at the very least, be acknowledging that. I don't think there's any room left anymore for a government in Canada to say, well, I'm not sure I really believe this or that. I think there's still a dispute about what's happening. I think we're past that. But then, so with all of that said, getting back to this question about, well, in practical terms, what's a municipality to do if they, just practically speaking, have no resources or no capacity to deal with the crisis? They can see it, they acknowledge it, but in practical terms, they can't really do anything about it. I think the report tries to address this in a series of sort of like short little hypotheticals or just illustrations that I hoped would maybe be helpful to readers to spell this out a little bit. And they come about, I would say maybe like 2/3 the way through the report. They're on pages 32 and 33 in the negligence discussion, and basically sort of offers a bit of a sequence of kind of imagining where you are. So the first one starts with a municipality that we assume just basically has no funding really available to it, and maybe has a suspicion or some thinking about, okay, well, we've got some coastal areas or some riparian areas or some old infrastructure, and we kind of suspect that we might be vulnerable, but we don't actually really know that for sure. We don't have the information we need to make a good decision. Like, we don't really know what to do. And in the context of this sort of discussion about core policy and operational distinctions under negligence, the report suggests that, well, maybe something a municipality in that situation could do would be at least to engage deliberatively in the work of saying, all right, we suspect there's a problem, or we suspect we are vulnerable, but like, apart from that, we don't really have what we need to deal with this. So what steps could we take to maybe, as a starting point, just get more informed? Is there anything that we could do? Are there potential collaborations or partnerships or funding opportunities we could explore to have some studies done, or to start seeking more information, or to start turning our attention to this in some capacity? So thinking about even little steps that can be taken along what might be a much longer journey is, I think, a prudent thing to do for any municipality, rather than just feeling totally overwhelmed or unable to face the situation. Just trying to come together, at least to look for even the littlest steps, and let those be your policy decisions that then carry you forward. That would be my suggestion in any case.
Well, this is a perfect segue to a plug for Climate Atlantic. I mean, partially that's what we're there for, right? To help those with very limited capacity just figure out what to do. So if you're interested, climateatlantic.ca, find us, and you can always contact one of us. So I've got a couple of things here. One is, Elizabeth Lee, I know you've had a number of questions on the chat. Most of them are not related to our topic, and I'd like to keep it limited to really the flood risk and the climate risk part here related to flood risk. And I think, we limited from the start very, very deliberately to one topic, because climate risk is a very broad one, which could go both on the adaptation side, like flood risk from events, as well as on the mitigation side, not adequately reducing greenhouse gas emissions. And so I'm just apologizing that I'm not bringing those questions forward, but this webinar focuses on this. There's one question from Stephanie, which actually fits really well with the whole idea of evolution of the law. How do you see the evolution of law around climate taking place? Will it be shaped by standardization and acceptance of certain standards of information, for example, flood maps, best practices of municipalities in communicating risk and setting policies, collaboration among the different levels of government in terms of who does what, etc.? Are there key factors that municipalities should consider in terms of starting these discussions and shaping the evolution?
That's a great question. I mean, I think to the first part, certainly all of the suggested pathways to evolution, I think are pathways. I mean, I think that the law always evolves. It's never one direct, straight path forward. It is, all those things coming together, all kinds of activities that are coming together to create sort of nexus of slow movement forward. So certainly I think all of those things mentioned. And I mean, in terms of best practices or activities, I mean, I'm not sure I'm in a position today to provide that kind of guidance. I mean, really the report focused on trying to sort of, identify and lay out maybe some things to consider rather than trying to provide clear advice. And the couple places where it does make suggestions are really about the ways in which the law of negligence quite clearly suggests that at the very least, having policy discussions and making sound policy decisions is a prudent thing for any municipality to be doing. But I think probably there's a lot of expertise on the line. So if others want to be putting in expertise, certainly in the growing fields of municipal asset management and the ways that municipalities are coming together to join various kinds of collaborative organizations in which municipal representatives are coming together to discuss best practices and ways forward in terms of, finding funding and looking for, all kinds of various policy initiatives that can help to support this work. I mean, I think there's so much information and activity out there that there's probably a wealth of resources to access.
Mhm.
But
yeah, I think you're right with that. And I would recommend also to look at the Climate Atlantic website. There's a lot going on in Atlantic Canada as well as beyond. And sort of when I'm sort of speculating forward, I suspect that, if that communities have access to so much information, there is no excuse for not paying attention. And so, hopefully that putting your head in the sand will disappear fairly quickly as we move on. I want to go just to one area that you briefly touched on, which is the municipal asset management. And I think that's always key for municipalities. And I've seen that also when I was councillor. It's just so fundamental. And you mentioned funding agreements. And I think we've seen over the last little while some of these funding sources and funding, especially the larger ones. So, Building Infrastructure Canada Fund and some of the ones that are coming out of the National Adaptation Strategy, they will likely more and more require the incorporation of climate change assessment, risk, etc., in project agreements. So if you're doing a project, you need to have assessed the climate risk or flood risk, whatever it is. Mm-hmm. So I think I found that really interesting that you're considering this also as this is part of contracts are legal contracts. And so municipalities, I always thought, well, you can sort of say that you're doing this, but in practice you can ignore it, but you can't really ignore it. If you need to incorporate climate change considerations in a project that is funded where you have signed a contract, this is a legal agreement. So you can be pursued on that aspect if you fail to do so. Am I sort of interpreting that too loosely? And I want to say that this is becoming more and more a fact. Like you need to include climate change considerations in especially those infrastructure development and repair kind of issues.
Yeah. So I think, the one thing, the reason the report addresses this a little bit is because when we first kind of worked together to define the research questions that would drive the report. And one of them was that beginning question of, well, what are the responsibilities? And so then I was, in the course of the early days of the report, kind of thinking to myself and doing analysis that would sort of scan for, where do legal responsibilities come from? There are a variety of places. Obviously, there's the law that governments enact, there's the common law, but then there are also the responsibilities that we enter into willingly. So the reason I included that aspect of the report that touches on the contractual arrangements was really to recognize that certainly responsibilities can come from there. A municipality can, through a contractual arrangement, agree to at least certain responsibilities to maybe consider or manage. Certainly with consideration, I think that plays into what we're talking about here in terms of developing climate plans of various kinds and et cetera, et cetera. So I think it's the responsibility piece that is likely most important in that aspect of the report. The liability piece, and I think maybe that's what you were getting at with the second part of your question. In terms of being held to those responsibilities. I mean, I wouldn't want to make too decisive an answer here because anything's possible. But I think the likelihood of failing to meet a responsibility under a contractual arrangement of that kind, where maybe municipality is required to do climate planning of some kind, it's maybe just that you don't get the funding, or you need to give some of it back, or you don't get funding next time around because of past performance and failure to perform contractual obligations. I don't mean to suggest, though, in the report or here that that those kinds of contractual arrangements can then be used as sources of liability for third parties who want to point to a municipality having had some responsibility to engage in consideration or management of some kind. So I'm not saying that an average member of the public who's totally outside of the contract could point to that contract and say, well, you had a contractual responsibility under this funding agreement with the federal government to do this climate planning, and you didn't. And so now, therefore, you're liable to me because my house just flooded, And so just to make it clear that I wasn't it's not discussed that way in the report. It's mainly just to say contracts are one place where significant legal responsibility can arise because you've agreed to do certain things under the contract.
I think that's a good clarification. Great. Thanks. I think we've covered most of the. Oh, there is one thing which I actually thought also interesting. You didn't touch on that one in your presentation, and this is the de facto expropriation. I thought that was really interesting, especially because of development pressures. So in many areas, there are already limitations on development, or that there likely will be in the future. And you say that if municipalities want to use regulation that changes the land use for a landowner, there are some risks, and that they should ensure legislation exists which immunizes them from liability. So can you explain this a little bit? Because really what we have is, developments are still happening. And as soon as you put some restrictions on development, you will impact a landowner. So a landowner will be limited in what they can do on their property. And that's, I think, the context. So maybe you can elaborate just a little bit what that is, and how municipality can manage that challenge of managing development in a climate appropriate way and not run that risk, right? And avoid running that risk, I should say.
Sure. So yes, happy to address that. And it'll take a little bit of backing up because I didn't, address it at all in this presentation. But in the section of the report that deals with common law liability, or potential sources of liability under the common law, one of the areas of the common law that is addressed is an area that is sometimes known as de facto expropriation, and that's how I refer to it in the report. Sometimes also referred to as constructive takings. You see a variety of language. It doesn't really matter for our purposes today which term is used. So essentially, de facto expropriation is a common law source of liability for situations in which a private landowner alleges that a government has effectively expropriated their land, but by going outside of the ordinary kind of expropriation regime that is established in the province. So provinces generally have expropriation regimes that clearly set out how a government, whether it be the provincial government or municipal government, can expropriate land, so take private land for public purposes. And typically these regimes require that certain steps be followed and that appropriate compensation be paid. But one thing that we've seen historically and has produced an evolution in the common law is that sometimes government action is seen or felt by private landowners to be so restrictive and to interfere so greatly with private landowner rights that the private landowners feel as though their land has been effectively expropriated, even though the government hasn't actually expropriated it in the sense of claiming it and having title formally transferred and all the rest. And so this is where the common law of de facto expropriation came about. And up until quite recently, developments in the common law over the past couple of decades had made it quite difficult for landowners to successfully claim compensation for common law or for de facto expropriation. But there was a recent development in the case law decision that came down from the Supreme Court of Canada just this autumn that reinterpreted the existing case law. Some say changed it significantly. It depends on the perspective you bring to it. To remain neutral, I guess I'll say today reinterpreted and reinterpreted it in such a way that that may conceivably make it easier for landowners to successfully claim that their land has been expropriated when it's been subjected to restrictive zoning or other development regulation. So the report goes into this in some detail, and one of the things that it notes is that in this recent decision by the Supreme Court of Canada, the court did make it clear, and this has always been the case, but the court really emphasized it, that if provinces and municipalities want to protect municipal governments from claims of de facto expropriation when they're engaging in land use regulation, one of the things that can be done is a province can clearly state in the municipalities enacting legislation that a municipality has power to engage in restrictive land use regulation without being liable for de facto expropriation. So the court basically said, this is the law as we're interpreting it. We are sort of broadening the interpretation to some extent. If you don't like it, legislate it away. Provinces have the power to kind of override the common law to some extent in legislation. And so that's effectively what the court is suggesting provinces do, or municipalities ask provinces to do if they're not happy with the new regime. So with respect to climate change adaptation, if municipalities are concerned that land use regulation that they want to put in place, say to help mitigate against potential destruction due to like coastal flooding or other foreseeable flood risks, if they want to do that, but they're concerned that the new interpretation of common law de facto expropriation is maybe going to open them up to lawsuits from private landowners, certainly one thing they can do to protect themselves is to advocate with their provincial government to consider legislative amendments that would more clearly protect municipalities. And so, I mean, they could take various forms, but presumably the government would want to consider something that would carve out a kind of protected space for restrictive land use regulation that would not be subject to de facto expropriation claims.
Mm-hmm. Thanks, that's good to know. And I think we also have some representatives from the Municipalities Association here, so who are usually the arms that lobby or advocate on behalf of the municipality. So it's good to hear. Great. So I think we're at almost 2:30. We said we wouldn't cut it off if there are any other questions. We've covered quite a bit of ground, but I also want to give an opportunity to those who hate typing in the chat and would like to ask a question in person, to give those people an opportunity to ask a question in person. So if you would like to just raise your hand and you can ask your specific question that way. Again, these are like Tina has said, you're not responding to specific cases. You can always only respond in general, but you're pretty good at keeping it quite general, not providing advice at all in that context. So is there anybody else who has a burning question that they haven't put in the chat, or hasn't been answered, related to climate risk and flood, climate/flood risk for municipalities and liability? I don't see any hands going up. Janelle, you'll tell me if there's any hands going up. If not, then this brings us to the end of our webinar. As you know, this has been recorded, so we have a number of folks who weren't able to come, and so we'll make sure that they have access to the recording. Tina, thank you very much. It's been a pleasure working with you, and I really enjoyed the webinar. I hope that this tool, the report, will provide some information to many municipalities. We'll promote it further, and we'll make sure that municipalities and the association have it in their hands. With that caveat that things change all the time, and likely in a year, this report will look very different, just because things are evolving as we go. So thank you very much for all your participation. Really appreciate it that you spent the last hour and a half with you. And please sign up for our newsletter. This is what we do, support communities and stakeholders and rights holders. Sign up to our newsletter so we can keep you informed about what we're doing. Merci beaucoup à tout le monde. J'espère que les francophones parmi vous vous avez eu.
Thank you all. I hope the francophone were able to listen in their own language.
Thank you.